Welcome to Looking at Legal Stuff. Today we have a small claims hearing with a couple who are suing their former landlords for breach of contract and wrongful eviction after they say they were illegally locked out of their rental house just 4 days after their lease began, all because they had concerns about the cleanliness and habitability of the home. They claim that not only did the landlord lock them out and terminate their lease, but they also refused to return their security deposit or even send them an itemized list of allowable deductions. They just ignored the whole thing. The landlord claims that the tenants are lying and that they're actually the ones who terminated the lease after just 4 days, when they sent a laundry list of complaints about everything that was wrong with the house and then refused to move in. Does the judge agree that the landlord had the right to keep their security deposit? Let's find out.
This is Countess versus Zinkai and Hariyama.
Please.
Who do I have on behalf of Counterclaim and Counterclaim?
We have both parties and me, Ben Schmerler, attorney.
Good afternoon. Mr. Schmerler, you're here on behalf of the plaintiffs?
Yes.
All right. And do I have anyone here on behalf of the defendants, Zinkai and Hariyama?
No, ma'am. We represent ourselves.
Okay, you are here representing yourselves. Good afternoon to you both.
Good afternoon.
And we do have a counterclaim on this position as well. All right. If I could ask all of our plaintiffs and defendants, counter plaintiffs and counter defendants, if you'll all raise your right hand, I'd like to swear all the parties in. All right. And Mr. Schmerler, you're an officer of the court. I think the only thing you'll probably testify to is to attorney's fees. So do you understand, though, that by appearing in court and offering testimony, each of you is affirming or swearing to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury? Do you so swear or affirm?
Yes, I do.
Fantastic. All right. All parties have been sworn.
When I raised my hand, the hand raise function happened.
I think that, I don't know if that would count if you use the Zoom to raise your hand. That's invented on Mr. Schmerler. I've not seen that done yet, but I'll see if someone gets invented. All right. I'll thank you all for being here. So I did read the petition. I've read the answer. I've read the counterclaim. And I think there might have even been, was there an amendment on this one? Well, quickly, just kind of my quick understanding. Plaintiffs, and here I'm referring to the Katoris, right? You all leased a house that was owned by the defendants. Shortly after you moved in, or immediately upon moving in, you said that the home was not ready to be moved into. You had to have it cleaned. And then you said that the defendant wrongfully terminated the lease and changed the locks on you. And I think it was like 4 days later. And so there is a contract claim from the plaintiffs for a breach of contract, a wrongful eviction, and fraud. The defendant responded and is seeking for the lost rent because the lease was not completed. Originally, you indicated that the counterclaim, your total amount of damages was $41,000, and you were modifying that to reach our jurisdictional limit of $20,000. Is that a correct statement?
Yes.
Generally? Okay.
Yes, Your Honor.
All right. So let's start with the counterclaim, only because for that one, we're going to have a jurisdictional issue. So Mrs. Zenkai, Ms. Hariyama, and actually, who is who? I'm so sorry.
I'm Junkai.
Junkai.
Yeah.
Okay.
This is
Junkai, Mr. Hariyama. So the state of law, Texas law says that my kind of court, a justice court, has jurisdiction up to $20,000. If your actual damages are in excess of that, you cannot file in a court like mine. So what you can't do is, because what your claim said is that technically you've been harmed $41,000 by this breach of lease, but you were saying, well, I'll just sue for 20 because that's your limit. That's not possible in Texas. The law says that's called a cram down, and I cannot hear the case at all. So it would be dismissed for lack of jurisdiction. You can still file that lawsuit if you wish to pursue it, but it would be in the county court at law. Okay? So it's dismissed without prejudice, meaning I'm not deciding whether it would have been a good claim or bad claim. I'm saying that as a judge, I'm not allowed to hear it because your actual damages, if correct, would be in excess of what I can give you. Okay? So that's for the counterclaim.
Yes, Your Honor. Our actual damage is in a file which I made. Defendant first amended counterclaim. Actual damage is not $20,000 or $40,000. Actual damage is $9,685, Your Honor.
When did you file the amendment?
I missed 7 days rules. I was busy for business trip and then coming back.
What was she doing? Ms. Zenkai?
I was doing. This is me.
When was it filed?
Yesterday.
Is that correct? Did y'all file the amendment yesterday?
I filed Friday. I was
Okay.
supposed
What
to do
time
it
on Friday?
sometime afternoon, 1, 2 p.m.
Okay, so I got filed late. Mr. Schmoller, are you wanting to proceed?
I
Need
mean,
time to review?
on their claim, I mean, we would object to their claim as a matter of law and for as untimely. I filed a motion saying that it was untimely yesterday. Uh, Further, their entire claim rises out of some allegation that my clients weren't actually trying to sell their house. Their house has been sold. So
I thought the claim was for unpaid rent because they moved out.
no, they have a fraud claim based on us allegedly lying about selling our house. It's just fundamentally not true. Our
All
clients have
right, all right, all
sold
right.
the house.
Let's be orderly. Let's take it like a court. All right, Mr. Schmerler, why don't you go ahead and make an opening statement? And Mr. Hariyama, Ms. Zekai, I'm going to go ahead and we'll just take all the information about the counterclaim and let's see where we get. All right, just know, but as you had filed it, definitely not something. If you're now saying no, our actual damages were something less, we'll take that and we'll see where we get. Mr. Schmerler, let's just hear it. We're justice court. All right. Real quick, because you're the plaintiff, Mr. Schmerler always gets to start. Because we have a counterclaim, Ms. Sekai, Mr. Hariyama, you'll also get a chance to make an opening statement and a closing statement, and we'll just kind of, the issues all arise out of the same thing. So it will probably be not as complicated as we think. All right, Mr. Schmerler, would you like to make your opening statement for me?
Yeah. So this is a case about unpaid rent, as you said. Basically, my clients were trying to sell their house, and with the expectations that they would buy another house. They sold their house. They wanted to look for a place. They didn't want to buy a house that they weren't 100% sure on. So they sold their house with the idea of then renting for a year while they looked for a place to move in permanently.
Okay.
When basically they requested a walkthrough, they were given a 45-minute interview and a 5 to 10-minute run through of the house. They requested a formal walkthrough where they could do the inspection type tests where they're going to look at the faucets. They're going to look like a formal walkthrough. And the defendants basically said, you're not allowed to do a formal walkthrough until you pay the security deposit and the first month's rent. My clients made those payments, and were still not afforded a formal walkthrough. Basically, what ended up happening was in January rather of this year, my clients took possession of the house, walked.
Is that when the lease began?
Yes, the
Okay,
lease.
so they signed a lease. Give me dates. They signed a lease.
They signed. Sorry,
When did the
they
lease
signed-
begin?
The lease began January 25th, I believe. I can pull up the lease right here. I was going to introduce.
January?
Yes.
Oh, I thought it was in the summer, but okay, January of 2025, the lease began. How much is the monthly rent?
The monthly rent was, well, it was different for the first 2 months. If I can just pull up the lease to make sure that I'm not. So the monthly rent was for the months of January and February was a combined $5,483. And the rent after that going forward from March of 2025 to January of 2026 was going to be $4,250 a month.
Why so cheap for the first 2 months? That's a huge discount.
It was just a negotiation between the parties, basically.
Was there a security deposit paid?
Say again?
Was a security deposit paid?
Security deposit paid as well as the first 2 months rent.
Oh, okay. Well, how much is security deposit?
The security deposit was $4,200 plus a $500 pet deposit.
Is the pet deposit refundable?
No, we're not
Okay.
asking for it.
It's not I always like when they call it a deposit if it's non-refundable. It's not a deposit,
Yeah.
it's pet fee.
Yes. So it's a
Okay.
$4,200 security deposit with a $500 pet fee.
And then the first and last month's rent, was that half of 5483 and 4250?
So this is not a standard lease. This is a lease that they've drafted on their own. And so, and again, I'm not really sure what went into the negotiations over the individual monthly rent. That's not really an issue here. Basically, they paid the first 2 months rent instead of the first and last month's rent. So they paid the $5,483. Shoot, sorry,
I
5,000.
got it. They paid $5,483 and the $4,700 for their security deposit and pet fee altogether.
Yes, exactly.
Okay. All right. So right at about $10,000 got put out by the plaintiffs in the beginning to get into the lease.
Yes.
All right.
And
And what day did they take possession?
they took possession on the 25th
Of January.
of January.
The 1/25/25.
Yes.
All right.
Oh, it might actually, I take that back. It's the 23rd. I apologize.
Okay. January 23rd.
Sorry, I have it in front of me. I'm not sure. But basically, they come in to take possession on the 23rd, having not been able to get a walkthrough prior to paying this 9,000 and some change. They come into the house. My clients immediately recognize that there is both safety concerns and cosmetic concerns with the house. The
Tell me
ceiling,
the safety ones, because cosmetic won't get you anywhere in Texas law. What's
I
the
know.
safety issue?
The safety issues was there was dry rot mold in the kitchen and in the bathrooms, and the ceiling was cracked.
Hold on. Dry rot mold in the kitchen and bath.
Yep.
And all the bathrooms or just one?
Just one.
Okay. Dry rot mold and what else?
The ceiling was cracked, showing a structural issue.
I mean, that ain't a health or safety issue. I'm going to show you every house in Shady Hollow.
Well, I'm
My
going to get
house has cracks in the ceiling.
Your Honor, I'm going to get there. So basically,
All
what
right.
the problem was, and the
No,
reason,
don't go ahead. Dry rot mold in the kitchen and bath, a ceiling crack. What else?
windows were broken, and that includes
How many broken windows?
What?
How many broken windows?
I have exhibits showing at least 3. I would say, if not more, basically, and there are various issues with various windows.
Mr. Schmerler, are the windows cracked or are they actually broken where I can stick something through it like a hole?
Well, so that's what I was going to say. So some of them are cracked. Some of them are off their hinges so that there's there's literally a hole where you can fit your hand through. And many of them don't lock. Which again, my clients were just seeing as safety concerns. And where this was really important is, and I understand the court's hesitance with regards to the uninhabitability arguments and cracked windows and cracked ceilings. But my clients,
the window won't lock, that's a health or safety issue.
Yes. And so here's where the real issue is my clients made a demand on the 26th. They did the report, like a Zillow report, basically, where they go through and it's basically an inspection. And they made all of these demands saying, hey, we're worried about these things. We're concerned about them.
Mr. Schmerler, did your clients send the defendants a letter that says, please repair or fix these things?
Yes. And so
what day was that letter sent?
That letter was sent on the 26th of January.
So you sent a repair request on January 26th.
Yes.
And what items specifically did they ask to be repaired?
The items that they specifically asked to be repaired, I can read them off to you. Hold on. Hold on. Select everything. Where is it? Is it above the pictures or below the pictures? Below the pictures. Oh, wait, no, the email. We made a request saying that the faucets, the leaky faucets, the bathroom, the dry rot mold, the windows, garbage disposal, and water damage in the cabinets all needed to be fixed.
Okay, with respect to the windows.
Yes.
Did y'all highlight what was wrong in which windows?
Yes, broken and or inoperable windows that don't seal properly, kick, and do not function as intended. We identified more than 5 windows with issues. During the initial meeting, the defendants indicated that there was one window that was locked shut, but other than that, they affirmatively represented that there was no broken windows and that they all operated.
All right.
And if I may just say,
is it copied? Because I'm looking, I got 129 pages of exhibits from plaintiff. Is that demand letter in one of these?
Yes.
What page?
It is plaintiff's exhibit 3, page 2.
Plaintiff's exhibit, well, so that's not how mine shows. Plaintiff's exhibit 2 is the Zillow report.
Yes, Plaintiff's Exhibit 3 is the email where we make the demand.
Okay, that's what I'm trying to get to. Exhibit 2 is long, lots of pictures. Oh, are those photos all taken at the time of the move-in?
Yes.
Okay. Exhibit 3. All right, so this is an email communication.
Yes.
All right. I'm just going to briefly share. I'm going to look at this and I don't see.
It's under major issues.
Yeah, no, I'm trying to cover up people's email addresses so I can share my screen and it not be, just showing the world everything here. Okay, I think we're good. I'm going to share my screen now so y'all can see what I'm looking at. And I've just put a little white box over where some email addresses popped up. But this appears to be a communication. I see that it's going backward, right? So this is the first letter is down here, Sunday, January 26th at 7:22 p.m. Hello, Kathy and Tomo, and then some information here. And so this is the letter that the plaintiff sent to the defendants saying we've moved in, here's the issues, and then here's a response.
Yes.
Mr. Schmarler's is copy. Is that guy, Mr. Hariyama, is this a correct copy of the communications between the parties?
Yes, Your Honor.
Okay. Let me just take a look at the letter then. When we initially met to see the house, you said the house was moved in ready with one window that was screwed shut. Okay, so they said there's one window that is screwed and won't open. After we signed the lease, we requested a walkthrough, said it couldn't do it, but we moved in anyway. Okay. So y'all had a chance to walk through it, but you didn't. Garbage disposal won't turn on. Substantial leak to the hose bib. Bathroom light is shorting and turning off. This one should be checked, right? I definitely see that's an issue. Texas says garbage disposal doesn't have to come with it. Substantial leak at the horse bib. That goes to utilities. This one though, if you got something shorting, I'd be worried. All right, we did not inspect because carpet and tile are being cleaned. Great. Yeah, I mean, that's true. Stains are stains, but they're not considered actionable. You have a shirt that has stains on it. Texas law says it's still functioning as a shirt. If your lease doesn't require that it be provided to you in a pristine, absolutely perfect condition, Texas law says you're getting the best of the bargain, right? So I get it, but let's keep looking. Areas of concern that are beyond cosmetics. This would be the thing that we need to talk about. Major issues: broken or inoperable windows that don't seal, lock, or do not function. We've identified 5 windows with that issue. Okay. Garbage disposal, water damage in the lower cabinets with sinks. Technically, Techness won't do that for you. The landlord doesn't have to test it. I had situations where unless you're already experiencing like a health or safety issue, it's considered a cosmetic thing.
May I interject really quickly?
Leaky faucets.
Can I speak to that really fast? The
Okay.
mold issue. So, and this is where the habitability concerns from our perspective.
Did you have anyone come in and inspect it?
We scheduled it. They locked us out before we could test it.
Okay. Leaky faucets in one of the bathrooms. Bathroom light turns on and off. This one's an issue. The windows is an issue. That's cosmetic. Many switches are not functioning. The on-off does not engage anything. Yeah, I want to know about that. All right, so definitely you've got some electrical and this window thing. That's a major concern. House isn't moving. All right, so due to these findings, we are not going to move in. We find that we cannot do it. We've canceled the movers. The house is not moving ready. We want a refund for our money and our deposit. Whoa. Okay. So you're offering a settlement with them. You're saying, I'll give you back January. And we want the money for the February because we're not going to move into this house.
Yes.
Please advise. And then you included a PDF of it. All right.
It is.
And then response, same night, literally 40 minutes later, right? We got your receipt as communicated. Replacing a few light bulbs, performing drywall touch-up. The rack was there before. We removed them. We need to touch up. Otherwise, we don't need painting. We said we'll fix the garbage. So, okay. Regarding the outdoor, we're aware of a minor leak. We tighten it. If there's other issues like the shower, willing to assess and resolve them. You cannot blame us on possible mode.
And we agreed. And we have text messages where
Mr. Schmerler, I'm reading still, right? Nowhere in here does it address fixing the windows. Right, and then this is the following day in the evening. from the defendants to the plaintiffs. Attached is the notice. We confirmed that Pano entered the house. We also confirmed the garage remote was left and nothing else as personal belongings were moved in. So everyone agrees that they never took possession. Not really. They looked through it, they set it back, they gave the garage door and moved away. All right. Mr. Smaller, what are your clients seeking today?
Well, we are seeking
Because they
a total out-of-pocket damages of $11,171.54. That comes from the $4,200 in the security deposit, the $5,483 of the January and February rent. There were mud services that we needed to employ for an $18.40.
there were what services?
Mud services, basically it was cleaning services basically of sediment in the water, I believe. And then and I was going to say the bathroom cleaning and the cleaning services were from this company called Big Guy Services for $1,400, $1,405.96. We're looking for our electric payment bill, like our utility bill that we paid for $64.11. And then we are seeking attorney's fees based on the contract and Texas Rule of Civil Procedure or Texas Civil Practice and Remedies Code 38 under a breach of contract theory. And one thing that I want to put before the court that is important is that under their lease, even in the event of default by the tenant, they had no right to retain our security deposit for anything other than normal wear and tear. Now, we never took possession of the house. So there can't be any wear and tear attributed to my clients. And therefore, them retaining the $4,200 security deposit is a breach of the contract itself. And as a matter of law, regardless of whether or not this is determined to be habitable, regardless of whether or not my clients were determined to have terminated the lease or they terminated the lease, they have no right to retain our security deposit. And my client should be awarded a breach of contract claim for $4,200 and their attorney's fees regardless. Because again, the contract does itself state that any victorious party, any litigation that arises out of this contract, the victorious party shall be awarded their attorney's fees. The improper retention of their security deposit is at bare minimum that breach, and entitles them to the $4,200 at a minimum plus we're asking for the exhibit. We have exhibits attached with our timekeeping and an affidavit of $7,501.
What's your hourly rate, Mr. Schmerler?
My hourly rate, it just went up, but for the duration of this case was $350 an hour.
Okay.
And I would say importantly, the big fact with regards to the habitability concerns, my clients sent that letter on January 26th. They offered a compromise. We received that response email that you read. And then I would like to say the following day, the following day on the 27th, we received, and this is attached as Plaintiff's Exhibit 4, we received a notice of termination of them terminating our lease. Sorry, I have Exhibit 3, my fault.
I'm trying to get there.
I am too, actually. I clicked on it every time. It keeps opening up Exhibit 3. This is from the following day, where they terminate the lease, and they allege in this termination that it's my clients who terminated the lease when there's nothing in that email that constitutes a termination. And they've attached this text message, which clearly my clients are saying that they're not terminating the lease.
Can Mr. Schmerler, I'd like to see it. I've got all 129 pages here as a PDF. Any idea where or what it's marked as exhibit what?
Exhibit 4, and it's a page.
Exhibit 4, page 1 of 2. I'm happy to share my screen. It does have some information on it, though.
No, let's see if it's exhibit 4.
Plaintiff's Exhibit 4, termination letter.
Let me see.
It's page,
Exhibit 8.
Page 73.
73. If that's exactly what I want to get. Thank you. Perfect. All right, I'm going to share my
Sorry.
screen now. All right. So this is what we have received from the plaintiff. This is what plaintiff says was the notice of termination they received from the defendants. So I can see it's January 27th, 2025. So 1/27/25. Notice regarding lease agreement and responsibilities. We're writing regarding your recent unfortunate email to terminate your lease. As you've indicated no intention to proceed, this constitutes a lease break under the terms. We acknowledge the garage door has been returned. Since you have broken the lease and did not make any personal, please simply discard the key. Definitely sounds like parties not understanding what each of them are doing. Because the notice, this is the notice. When we met, you stated the house was move-in ready. After we signed it, we requested a walkthrough. Got it. No one did it. Y'all still moved in. Or you signed the lease, right? After got the keys, we went inside to take a look. Said, hey, can you fix these things? We got it cleaned. Okay. So that's why they didn't move their stuff in. They had it cleaned first. We identified areas of concern. We're giving you our report, which typically is done by a tenant when they move in, and they went ahead and did one themselves. Okay. I don't know about 2 weeks. It kind of depends on each landlord, but an inventory form is a good idea. I mean, right here, they do request a termination of the lease, right? The house is not move-in ready, and we would request a refund for our deposit and the February payment because we're not coming, and termination of the lease. And then they offer how to get out of it. Hey, we want to end. Here's what we're offering to do. And their response from the defendants is, you've ended the lease. We say that counts as a lease break. We acknowledge the garage remote's been returned. What I hear then is that a lease was broken, but you're saying you had a right to break it because it was not habitable.
No, what I'm going to say is if you look on that page,
Mr. Schmerler, how else can I interpret this language?
that's
We
what I'm trying to tell you.
A termination of the lease.
I'm going to show you. So if you go back to that exhibit, that page 73, they say attached as Exhibit A. If you go on attached as Exhibit A, that is what is a text message where it's a text message from the following day between our clients, where they ask us, like, hey, we sent you an email and we said we are evaluating our options, continuing our inspections, and getting a second opinion. That was sent on the 27th.
I don't think that is strong enough to overcome we wish to terminate right here, right? Like, because this doesn't say in the text message, hey, we're evaluating options to stay or to reschedule our movers. I mean, that may be, we're calling a lawyer. I don't know.
Continuing our inspections is what is the important part of that, because they were
evaluating our options.
Yes.
But that does not, Mr. Schmerler, that does not change the very clear language used in the letter 2 days earlier. Termination.
And again, they responded. I got it. And they respond. And again, this was a suggestion of what we could do going forward.
And they took it and said, all right, you want to terminate? We agree. You're gone.
Well, actually,
now we're getting into the damages.
They responded to the email saying that, hey, you're going to be responsible for for the whole lease terms rent.
Sure, they're not going to get that. They're not going to get that.
No, I know. They said that in the email responsive to the one on the 26th. They then sent us a text message in the morning following that saying, what do you want to do? And they said, we're evaluating our options and continuing our inspections and getting a second opinion. And again, had there been any communication, like they had scheduled mold inspectors, and they had told the parties, hey, we're going to continue to get this tested. We would like to see if this is a habitability concern and then we can terminate the lease correctly. Okay. It was just a clear indication that they were not trying to terminate the lease until they had done more due diligence.
Mr. Schmerler, did there come a point where the defendants changed the locks so that your clients were no longer allowed entry?
Yes.
4 days.
So that happened. If we moved in on the 23rd, that was a Thursday. They locked it by the following Monday, 4 days later. So the 27th.
What day would that be?
I'll tell you. Hold on. Let me see.
January of this year?
Yes, it was, again, 4 days after. I would say it's the 27th, but Hold on a second. Let me pull up my calendar. Monday, the 27th.
Senator Zaffarini calendar she sends out to just the piece. And if y'all want so fancy, I got
Yes. Monday, the 27th.
Monday the
was when they-
27th. Okay.
Was when they had changed the locks. And again, my clients were unable to continue inspecting the property to determine whether or not there was habitability concerns.
Yeah, I got it. If the locks are changed, you don't have access to it. Did your client, after the locks were changed, come to the court and seek a writ of reentry?
No.
Did they take any action to get back into the property?
No.
At any point after the locks were changed, did your clients receive an itemization as to their security deposit?
No.
Did your client provide a forwarding address?
I don't know. I'd have to ask them.
That's a question to ask right now. It's going to trigger
Alexis.
things under the property code. Did you give a new address after you left? So they changed the locks on you. You didn't try to get back in. Did you say, here's my address, mail me my security deposit?
Yeah. Yes.
They're on mute. Your client's got to unmute so we can hear it.
Okay. Sorry for that. Good afternoon. It was our original address, our house.
What I'm asking is, after they gave you said, here's the garage door, the locks have changed, you can't get back in. After that, did you, in writing, communicate to the defendants, this is the address for you to give me my deposit at?
No.
No forwarding address ever given. All right. Mr. Schmerler, at any point, have you sent a demand letter to the defendants and asked for the return of the deposit?
Hold on.
Yes, we did.
I believe so. Let me find out. Let me make sure I have it in my hand before I say yes. So we sent this chapter 27 letter, correct? Hold on. Hold on, we found it. Right one?
Yes, it was sent on February 13th.
Yes, it was sent on February 13th, 2025.
It said February 13th.
Yes. Where's that?
Okay. So within the first month of them moving out or the lease ending, plaintiff did send a request for reimbursement?
Yes.
Okay. You said that was the 13th?
Yes.
Okay. All right. Did your office receive a response to that demand?
No.
All right. I'm going to share my screen, Mr. Schmerler. I'm going to highlight, I would like to review the lease with parties. Just like, let's look through the lease as well as some of the photos that were taken, okay?
Okay.
All right. So this is, and it's many pages. So I want y'all to bear with me, but it's many pages. I would say from page 1, it looks like the lease goes through page 11. And then, well, yeah, I think it does about page 11. So let's just look through this together. I can see that this is a lease that was created most likely by the defendants, or at least it is not a template lease in the way that I typically see something like a Texas Association of Realtors or a Texas Apartment Association lease. It has many of the same terms and conditions, but it is not in that format. So we'll just take a look. So identify the land, identify the premises, identify the occupancy. It's for personal use only. Terms of the tenancy, I can see exactly what y'all said, kind of an odd thing. It is sort of the end of a month and then go to then, which then explains more why the rent was a little bit different. So it was actually March to January the 5th, but that first 2 months were that something different. So yeah, much different, prorated and then a full month for February. Okay. And then they give some account numbers. Return checks and other charges, security deposits going along here. I see maintenance responsibilities. There is a $4,700 deposit and then within 30 days of vacating the premises, returned keys, and provided landlord with a written forwarding address. So the lease was ended, locks changed, January 27th. Counsel for the plaintiff say that on February 13th, within 30 days, they did make a demand with an address and say, please provide me with a deposit in full. Utilities, that was them, maintenance, conditions and clean, access for inspection, extended absence, repair and alterations, except as provided by law. Tenant will not make any repairs or alterations except as provided. They will not consent to key anything. Any additional things must be repair and remedies if it affects physical health or safety and the tenant is given notice as required by law. They say 7 days is considered reasonable and landlord fails to remedy it, tenant may terminate the lease. In this situation, tenant took possession by getting the keys and looked into the property on the 23rd. 3 days later, they notified the landlord of situations, and it was the following day that the lease pretty much came to an end. So landlord did not take 7 days to repair. Instead, they moved forward and said, you've ended the lease. So, confusion between the parties about that one. And then you're supposed to get renter's insurance, attorney's fees and cost. That's always standard in these things. Authority to receive legal papers, lead-based paint. Okay, reasons for them to terminate the tenancy from the landlord's position, validity rules, additional provisions. All minor repairs up to $300. Good faith yard maintenance. Gonna take out things and put in new stuff. Okay. This is our entire agreement. All parties signed it. Okay. All right. Ms. Sakai, Mr. Hariyama, is that a correct copy of the lease between the parties?
Yes, Your Honor.
Okay. And then Mr. Schmerler, your clients did take it upon themselves to make a property condition form, and they just got a form from Zillow and used it?
Yes.
Okay. So here we are. They make some notes of things, right? I see floors, walls, right? They're kind of filling it out here. Paint, paint. And so here's an outlet that doesn't work. 2 burned out. We're not sure about this one in the closet. All right, so here we have light bulbs not working. I don't know if that means the light doesn't work or just the bulb's not working. Here's a switch not working in the living room. Here's an exposed cable, an inoperable light fix in the bedroom. That's 2. Here's the 3rd one in the bathroom. Here's a broken window. Which window, Mr. Schmerler, which window do your clients advise you? Because it's not in the lease. They said there was a window that they told was already broken and couldn't be opened, that had been nailed shut. Do you know which window that was?
I have no idea where it is on the house, but it's in this exhibit list. Pano, do you happen to know which window you were told
Yeah.
was locked shut?
It was in the master bedroom downstairs. We noticed it when we were talking there because it was a metal screw on both sides of the window.
So this one right here that's marked inoperable, this one y'all were told about, the downstairs bedroom?
Yeah, it was
Okay.
primary,
But the
but
one-
downstairs.
But is this is bedroom 1, the primary bedroom, different than the downstairs bedroom?
Yes.
Yes,
And in both rooms, the windows were not operating?
yes.
Could you open them at all?
The one it was shut. Some of them, the bar on the side, it was off and it wouldn't open. We found, as we said, 5 windows that they were like that. And then upstairs, there was a cracked window. The glass was cracked. And, when I tried to open it, it was showing that it's going to shatter, and we stopped trying.
Okay.
And some of the windows, they wouldn't lock. And some of them, you can actually see outside. They wouldn't come down all the way. And you can actually see the outside.
Okay, let's take a look at some of these pictures then. Mr. Coutures, Mrs. Coutures, do you recognize these photos?
Yes.
Who
Yeah.
took these pictures?
I did.
What day did you take the photos?
The 20, I believe it was Saturday. It was a Saturday, 23rd. We got the
25th.
keys. 24th, I have medical appointments, so 25th.
25th.
Took the photos on the 25th? Okay. And you received the keys on the 23rd. On the 24th, on the 23rd or the 24th, did you have any crews that came in and did any work at the property?
So on the 23rd, I had scheduled the carpet to be cleaned as well as the tile to be cleaned.
And were both of those done?
Yes, ma'am.
So the carpet and tile was cleaned on the 23rd? So these photos were taken after you'd already had a crew come in to clean the tile on the carpet?
Correct.
Correct.
Okay.
And yeah, Friday we weren't at the home at all because I had medical appointments. So we did not visit the home at all on Friday.
Okay. So let's take a look at these photos, and that just gives me when these photos were taken and who took them. So we have some evidence. Okay. So front door. Sometimes I'm gonna zoom in so I can see these a little bit better. Front door. What year was the house built? Anyone know?
2021.
Oh, this is a brand new house?
I'm sorry, 2001. Yeah.
2001. That I believe, because I'm like, that front door looks, I know a lot of people with that front door, and that's definitely a different time. Okay. All right. That just gives me, so we're gonna looking at a house that's about 25 years old now, or 24 years old. Ooh, that's a pretty chair rail. I see there's an X. Oh, forgive me all. Oh, I see there's an X on this outlet right here. What is that X denoting? Well, first off, who put the X on this picture?
I did.
Okay, and what is the X? What is we're trying to indicate with that?
It means that when I flipped the switch on and off, nothing happened.
Okay, so this is one of the outlets that you couldn't determine that it was working or what it went to. All right. How about this X?
That means that particular window is not operating. Either I couldn't get it up, it just was not working.
Okay. This is kind of the separation you noticed in the house? This way?
Correct.
Yeah, I'm familiar. All right, holes in the screen. Yeah. How about this? I see a picture close up of a window with two locks on it. What are you showing me with this photo?
They're not locking.
No, these are locking, but it's just the inside of the window is deteriorating, and it's just showing that it's deteriorating. And some of these photos are cosmetic.
Yeah, no, I get it. You're not wrong to document cosmetic damage at the move-in. In fact, I think it's smart for tenants to do that. That way you know the severity. If you say it had scratches, is it this kind of scratch or is it a Jeep gouge in it, right? So I'm gonna look at all the photos. I absolutely understand that some of these are not things that it would be actionable that you would even have pointed out to the landlord. Just you're making note. This is what you got day one when you took the keys and you looked at it. Okay. All right. So I'm looking for the things I'm looking for, which are the health or safety issues, right? So I see it's like this is no fun, but unless you've got a big swarm of them, typically that doesn't fall within our health or safety issues. The odd one here and there, right? Let me watch out. A cricket's going to follow my head from the pop-in ceilings here. All right, now there's a lot of circles on this. Is this just showing that these are scuffed, that there's paint marks missing? Okay. Okay. And then up here, these doorknobs.
Same.
Okay. All right. Yeah. More. Truly, all we have a house built in the same time. I think I have that exact chandelier. Mine's, but we stuck it all the way to the top because we don't use that room as a dining room. How about this one? This lock. Actually, I'm sorry. Let me start with the top photo. I see there's two red X's. What are those X's for?
Yeah. So those windows have issues. I believe the one on the right is the one that you'll see that photo down below at the bottom of your page right now.
Yeah, it won't. Will it not? Is that as shut as it gets?
Correct.
Yeah.
So one side shuts completely, but the other side stays up. We were not able to get the other side down at all.
Okay.
Like that was the most it will go.
And you can see
I
this
see
the
that gap
picture
here.
above. You can see the bar on the picture on the left.
Mhm.
That if you move your mouse toward the left, you can see that little bar over there that prevents the window from closing properly. That's part of the window that is broken.
That little thing right here?
Yeah, exactly. That shouldn't be there. It should be part of the moving window.
Okay. All right. Oh, dirt daubers. How about this blue arrow? Are these
That's
are the
just
lines
the shutter.
broken?
Yeah,
Yeah.
that's just the shutter.
Okay. Is this these outlets? Are these outlets not working?
I don't know what they went to. Yeah, I couldn't turn anything on or off with those. And I don't know, maybe it was light bulbs, maybe it was something else. I don't know. I don't know what the issue was.
That's your range top or the stove.
Mhm.
Yeah, that looks like a leak. I see what you mean. Then it sat. Yeah.
And that was the main concern that we had when we
Oh,
visited.
this is the window, I'm sorry. This is the window that they did shut. They see the metal piece on the right-hand side on the bottom picture.
Yeah.
That is what they put there, so we're not able to open or close that window.
Okay. Is that window within this room here?
Yeah.
I believe it's the one across from the entry door.
Yeah.
All right. And how about these two pictures? These two X's.
Those had problems, those windows.
What kind of problems?
We couldn't
The
open.
one on the left was the one that was screwed shut, and the other one, there were gaps, and you can tell that in the past they put tape, and then there were like bugs like stuck to that section, like bugs were coming in from that.
It wouldn't
section.
close or open properly.
Okay. I want to revisit. So this picture on the left, I'm looking at, there's two windows. There's one that's like a half window and one that's doubled, right? This single window to the left with the red X on it. Would this window open or close at all, or was it nailed shut?
Nail shut.
And is that a different window than the window in the photo we just saw that has this, or is this the same picture?
The same.
That's the same window. Okay, so this is that window. Okay.
Yeah.
All right. And then this one, could you open and close it?
I don't think we tried
No.
it. We just saw that they had taped it in the past. Honestly, we were very scared. We did not want to damage anything in that house
Okay.
by opening and closing, or because it looked like it was in bad condition.
I like the tile job. They just left this little piece here. Right. That's the guy who tiled it in 2001 was like, oh, wait, I should have measured different. I'm like, yeah, whatever. It's just a piece from the top of this corner. They just stuck it there. Anyway. All right. Light bulbs, broken light. How about this one? Did this outlet work?
No.
No.
Okay. Yeah. This is a common sight. Don't we know it? Texas is hot. How about this picture with wires under the window sill? What's this one?
That couldn't close.
So that is part of the window, that piece that I don't know, I'm not a window person, but all that was like on the side of the window. I don't think it was there. It's supposed to be there, but that window had an issue. And I think that's why it has an issue.
Is
And
this,
that's
we looked
another
at a photo. What room is this window in?
I don't remember. I think. Yeah.
I mean, I can see outside the window. There's like a little sidewalk out here. Is this the side of the house or the neighbors?
Yeah, something like that. But I cannot remember. I mean, we only.
Second floor, Your Honor.
Is that the ground floor? Is this the same window?
Second floor, Your Honor.
Second floor.
Yeah, the same.
Pescatores, is the photo here on the left, I'm sorry, on the right, there's the ceiling fan, and then to the right of it, there's the photo of the wires, and then there's a photo of a window below it that's off kilter. Is this the same window?
I don't remember.
Okay.
I just cannot remember. It's so many that
That wallpaper. Yeah. Is this the plastic on the inside of the window is beginning to chip and break? What's that?
So that's at one of the window sills. I believe that was upstairs, the upstairs window. It had some issue there, and
That's leaking. That's
may
definitely-
I add something, or may I share something with you, Your Honor?
Of course.
So on the 23rd, when I was there, I was not feeling well like when I was in the house. I had heavy phlegm and I was coughing, and I thought I was getting sick. I didn't think anything of it. And then Friday, we didn't go to the house at all, and that cleared up. And then when I went back to the home on Saturday, I had that phlegm again. So I was thinking maybe there's something in the house that, and then I found all that water intrusion. That is why I suspected maybe I should get a second opinion and notify the landlord. And before I had an opportunity, the landlord told me everything was okay. And just for my, peace of mind, I wanted to get a second opinion. I'm not the expert here. I don't know. And we were locked out before we could do that, just hours before my appointment.
What are these pictures of?
It's in the laundry room, the outlet in the laundry room. We were just testing to see if there was power to that outlet. And the top one did have power, but the bottom one did not.
Whose hand is that?
that's my hand.
Okay, so you were testing the electricity. Is this the only outlet that you found didn't have any electricity in it?
I didn't test
No,
it.
it went.
I didn't test everything. I just tested this because that's where we're supposed to be plugging stuff in the laundry. And I just wanted to make sure that it worked. I didn't test all the outlets in the house.
This in the laundry room? What's this?
That's the laundry room, I believe.
Okay.
Or maybe, oh gosh, was it the laundry room?
I don't remember. I don't remember.
All right, anything further, Mr. Schmerler?
No.
Governor, Ms. Sakai, Mr. Hariyama? All right, so I understand that you have a house. Do you still own the home?
Yes.
All right, after the plaintiffs moved out, did you release it again?
Yes, Your Honor.
When did the new tenants move in?
July 13, Your Honor.
Okay. It's a beautiful home. What's the square footage?
3,500.
3,500.
Yeah.
Good answer.
Cool. All right.
Good answer.
Were you able to get, when you relet it, was it for $4,250 again? Or did you get more money the second time?
For the second time, currently is 3950.
350.
$39.50 because the tenants require have 2 years lease. Want to give us negotiate
okay.
the discount.
Oh,
And they have a ESA dogs.
okay. Very good plan. All right. In the photos that I just reviewed that were taken by the plaintiffs, did you see any photos that you thought were inaccurate or mischaracterized? Or are those photos all accurate to the way the property looks?
Yes, Your Honor. There are many pictures, excessive, eccentric, microscopic pictures taken by plaintiff.
Okay. Now, when you received the email from the plaintiffs that said, we took the keys, we've looked at it, here's the things we have, and then you responded. In your response, you indicate that that you believed they were terminating the lease and that therefore the lease is now terminated. Is that correct?
Yes, Your Honor. And
Okay.
then we have a precise timeline to unfold the sequence of event.
All right. When did you have the locks changed?
It is after we confirm their not move-in, abandonment, and non-repudiation of termination notice. I rekeyed it on January 27, I think, night.
Okay.
January 27.
All right. Now, did you receive the letter from Mr. Schmerler in February asking for the return of his client's deposit?
Yes, Your Honor.
Okay. Did you respond to his letter?
Yes, ma'am.
When did you respond to his letter?
Immediately, I think, within a week, I think we mailed out.
Do you have a copy of your response?
I do have everything in my exhibit. I attempted to submit, but I failed 7 days.
Let me take a look. We have several things, so let me look in here and see if I can.
Thank
find
you.
it. Absolutely. Okay.
Okay.
All right. Mr. Schmerler, do you work for the Gammon Law Office?
Yes.
Okay. Well, let me share back the letter that we received. All right. Well, this is a letter defendants have provided in advance as a copy of an exhibit. They said that this is the letter that they responded to plaintiff's counsel after receiving that demand letter. So stated February 22nd, 2025, says it's via USPS priority mail to the Gammon Law Office, response regarding lease breach, termination, and misrepresentation. Mr. Schmerler, do you know if your firm received this letter?
I've never seen it before.
Do you know if any what your law firm has?
I don't believe so.
Okay. All right. Dear Mr. Gammon, this letter serves as our formal response to your client's recent allegations in a letter dated February 13th regarding the lease agreement. After review, we categorically deny these things. Wrongful termination. They clearly indicated they'd not taken possession, had never moved in, and wanted a refund by disregarding the damages caused by them upon us. Okay. Despite our offer of a key off over and walk through to remedy any suggestions that unilaterally sort of termination and demand a refund. Okay. On the same day, we sought clarification regarding their termination. However, their response on the 27th failed to repudiate and cancel the termination notice and refund, and you'd already changed the locks anyway, so got it. You took their letter to say you're terminating, and they moved forward with it. And so as a result, they breached, and we think we can keep it. All right, misrepresentation. They've alleged the property is uninhabitable by a loan form available at Zillow, not legally required to use. Well, they can use any form they want. They could have made that same thing, just taking a piece of notebook paper, right? Like any form they use does not matter if they want to make a documented effort as to what's the state of the property when they got it. So they can do that. Do not accurately reflect or even contain false claims. I mean, I don't know. Let's see. I think people may misstate how strongly something is, but I mean, I saw the photos. There's back and forth. Overall, anyway, okay. We assert actions are a breach of lease as they resorted it without available good faith remedies typically required. So you're right. Neither party waited an amount of time to actually do anything, right? Like defendant didn't say we have a chance to fix it, and plaintiff didn't say fix it first. Y'all both kind of vague and acted in reliance upon both of you having kind of vague assertions, and as a result, lease got terminated. All right. As a result of this writing, public records, TAR and Zillow confirmed that status has remained pending. And then there's kind of this theory that you think they were just trying to buy a house and move along with that. And I mean, I don't know. Okay. All right. But let me share that again, because what I'm looking for is what happened to their deposit, right? So we cease and desist that we demand that they cease and desist from making unfounded allegations. They remain financially responsible for the full term lease unless and until we secure another tenant. I mean, that's not completely inaccurate to some degree. Failure to comply with calculations and liabilities and damages, but you did not in any way, shape, or form mention their security deposit. All right. So that's a violation of the Texas Property Code right there. All right, y'all. All right. And Mr. Hariyama, you said you filed an amended petition today on your counterclaim, correct? Or you filed it just a few days ago?
Yes,
All
yes.
right, let me pull that up real quick. Let me just see what you had removed it down to, or what you had amended to. Okay.
Included.
First amended counterclaim. Let's take a look.
Yes, she picked up this one.
Damages. Our tenants moved in July 12th. Okay. No. Okay. All right, guys. Thank you all very, very much for all of your attention and the information you've given me today. But I think I already know where we can go with this one. All right. Both couples behaved as many couples do. I don't actually find that anyone behaved completely irrationally with how they went about it, right? I think that the house that was being rented is a home that's not uncommon and in most part fine and dandy for the many things. Absent the issue with the windows, that is a health or safety issue. You cannot have a home in which the windows are not opening and closing, and in which they need to have a repair. Now, having said that, the lease and the law, even if you had just handshook it, says that the landlord has an opportunity to fix the problem. What I definitely see, per the language used by both parties, is that an understandable misunderstanding occurred, right? Confusion happens here. Y'all thought, well, we might terminate if you don't fix it. We want to try to figure out if there's really a problem. But definitely the way you wrote it, asking for offering to terminate and offering the money, I can see why the defendants said you're terminating. And then there was this sort of vagueness in that little bit of text message and not any real honest to God, like pick the phone up and call one another, despite y'all having done that in advance. So locks got changed. Per the statute, once the locks were changed and the tenants did not seek to have a writ of reentry, because you would have gotten back into the property if you come to the court and said, hey, my landlord locked me out illegally, right? You didn't do that, which I take to be a ratification of this position that, we don't really want to lease here anymore. Let's all call it a day and come to the end. What money was spent? So the plaintiff paid a security deposit and they paid for January and February rent. The defendants were not able or did not relet that property until, I wrote it down. Was it July? Is that what we said?
July 13th.
July
Okay.
13, despite our active tenant placement, Your Honor.
All right. Now, under the property code in Texas, once the lease ends and the tenant provides you with a boarding address, even if they've breached the lease and moved out early, you have an obligation as the landlord to provide an itemization or a refund within 30 days. Failure to do that prevents you from recouping anything whatsoever. And in fact, failure to itemize is deemed as a bad faith act, and that would allow the plaintiffs to seek treble damages. I don't find this to be in the same frame. I think there is a misunderstanding and a misapplication on both sides about what your options and obligations are. I do feel, though, that it would be unfair to allow the plaintiffs to lose all of their money when they did not get the benefit of the bargain, certainly with regard to living there for February or with regard to their security deposit. Now, having said that, because there was this sort of strange breach by both sides, it really does. Y'all both seem to have acted in misreliance upon some confusion there. The defendants didn't rent the property out for several more months, right? So they otherwise had anticipated making some income, which they could not because tenants didn't ratify and come back in to keep paying the rent and then inspect it and then prove their case. They just said, cool, the locks are changed, we'll move along, and did. And that may be for the benefit of everyone. So what does that mean in terms of damages? All right. So you put down $4,200 for your deposit. You paid $54.83 for January and February, and y'all already broke that down for me, right? Didn't y'all break that out in that lease in a beautiful way as to what January was versus the other?
Yes.
Sure. That's right. January was $12.33. Okay. February was $42.50, right? right. I'm going to find in favor of the plaintiff and the original claim. I'm going to award the $4,200 security deposit be returned. I'm going to award $7,500 in legal fees. On the counterclaim, I'm going to allow the plaintiff, I'm going to find for the counter plaintiff that they were obviously entitled to the $1,233 for the January rent, as well as the $4,250 that was paid for February, but I'm going to deny the remainder of the claim, which means that plaintiff, the counter plaintiff has already been paid. And so as a result, the money that should come back to the plaintiffs in this case. So the judgment will be, and I will stop saying plaintiff and defendant to make it clear. The judgment is on behalf of Mr. Katoris and Mrs. Katoris. You are going to receive $4,200 of actual damages, which is your return deposit, and $7,500 in your attorney's fees. On the counterclaim, essentially you're going to take nothing because I find that you've already been compensated by keeping the rent for January and February. All right, so counter plaintiff takes nothing. Original plaintiff, it's going to be $4,200 in actual damages and $7,500 for the attorney's fees, so that your total award is $11,700. All right, and also your cost of court. Now, both parties have the right to appeal me. You have 21 days to appeal the decision of the court. If you take no action, the judgment becomes final on day 22. You do not have to wait for the appeal period to finish before you start contacting one another about settlement or payment or post-judgment collection. But again, if you take no action, it becomes final on day 22. All right.
Do I need to get you an order, or do you guys have a?
No, Mr. Schmerler, we've got an order for justice court, but I appreciate it. All right. Can I answer any questions?
May I have our words regarding their failed sales of excursion way and recent completed sales of excursion way? I know your Honor covered my counterclaim, pretty much good portion. And we know that plaintiff's attorney spelled out so many untrue facts.
Yeah.
We possess a video, pictures of very detailed walking through broken windows, accused, leaky faucet. We have everything to counter their accusations. I wish your Honor to take this into account. Therefore, I know we spend time, but we would like to orally request, postpone, or allow us to submit the original video files, then allow us to state our position regarding condition of house. Our house with two previous tenants, decent family, and current tenants do not deserve microscopic, excessive, literally abusive report.
Mr. Hariyama, I did not find that your property was insufficient, or that I didn't find that you had a bad home. I think your home was habitable. I think there was a confusion reached between the parties by your words and statements in the first 5 days. Here's the issue. The plaintiff should have given you a chance to repair. Y'all did not do that. Instead, there was a vagueness. Y'all changed the locks from the defendant's side, and the plaintiff did not take action to remain as a tenant by coming for a writ of reentry. That is why I find that both parties breached the lease in their own form or fashion. Yes.
Your Honor, Sylvia, so we have been patiently listened about the plaintiff standard lawyer and your discovery process. So I want to grab the chance and then to list a few items. Number one, plaintiff physically viewed our house physically. They spent their 2 hours and before sign a contract, and even chat with us, said they had a motivation to sell their current house because the husband's job is close to the hills and that they want to get in closer. So we gave them enough time at that moment before signing a contract, they can go through everything. Number two, when during that time, and then we have one window, we clearly acknowledge that we also offer them, if you have anything, and just list those, and then we will offer to repair. So these are the two things. Number three, so we found out they lie about actually they could not move in, they default, they could not sell their house. Their house is go to the default contract. And 2 months later, we found that they bought the house in the hills, same community. So in other words, is we have enough reason and then to doubt that behind the motivation, intentionally breach the contract with this kind of malicious photo. When I mentioned malicious photo and the plaintiff was lie, you listened, owner, you asked her, you took this photo, is it before cleaning or after cleaning? She clearly answered, is after cleaning. So what kind of the cleaning office they got? After you cleaning, you still have the roaches on the ground. Do you believe that?
Ms. Akai,
Yeah.
none of that is important to how I decided today.
Yes. Yeah. Okay.
None of those things are relevant to the decision I reached. When you change the locks on your tenants, that's a breach of your duty as the landlord. You cannot do that. And they, let me finish, and the plaintiffs should have come to court and got a writ of reentry. The fact that they didn't, I take as proof that they wanted to terminate the lease. That is why I find that both parties mutually agreed to terminate the lease. That's why I'm letting you keep the money for the rent. But you did not itemize their security deposit. The fact that you didn't refund it at all means they could have sued you for 3 times that amount. I'm not awarding bad faith or treble damages. I'm awarding them back their deposit, which you should have returned many months ago, and the cost of their attorney's fees because they had to hire someone to bring you to court to get the money that you should have returned all the way back in February. None of the pictures are relevant to that. I believe your home is good and habitable and probably being enjoyed by the new tenants. I did not agree with their position. What I found is that both parties breached the lease. And after that breach, y'all made a mutual agreement to terminate it. After the termination, you had a duty under the law and your lease to refund or itemize. You did not do that. That's why they get their deposit back. And because it took them getting a lawyer and coming to court, they get their attorney's fees. That's it. Okay. Miss Ma'am, you're back on mute. You'll need to unmute again. There you go.
Oh, yeah, yes.
Can you unmute?
Yeah, already.
So again, I did not find, none of my ruling says that your home was uninhabitable or not in otherwise good condition. That's not what my ruling is. It's that y'all made a termination and then you didn't refund them their deposit.
Yeah. So
Okay.
what I want to mention about your owner. So as you know, as the small landlord, so in Texas, you know, for the 2025, the rental market is kind of difficult. So first of all, and then due to the plaintiff delay, so we missed the best time because they preserved our house from December to the all the way January. You know, basically as a landlord, we rent a house, we know usually is a holiday season.
I'm not awarding you anything for lost income because y'all mutually agreed to the termination and you did not refund their deposit. I can't say that enough times for y'all to understand what I'm getting at here.
Yes.
You could have been sued for 3 times that amount. It would have overwhelmed the amount y'all were seeking. That's not happening. So the judgment today is judgment for the plaintiff for $4,200, their deposit, and $7,500 for the legal fees. All right. Okay. All parties are excused. Thank y'all very much.
Thank you.
Thank you.
Good luck. Thank you all, everyone. Again, beautiful house. I've got cracks in mine and my corners too. I feel that.
I'm from Baltimore, Maryland, if it means anything. I didn't realize that was so common in houses in Texas.
It is beyond common. It is.
I
You
truly
can't buy a
didn't
house in most of
misrepresent
Southwest
something there.
Travis County without encountering that.
I just didn't want you to think I was misrepresenting anything.
No,
there.
I appreciate it.
I
No, it
just-
is. It's
truly didn't
cosmetic
know.
cracking in the paint and the joints is not completely uncommon. It typically can lead to there being something going on.
Okay, fair enough.
I'm praying to God that mine is not as bad as I fear.
Okay, all right. Well, you have a good one. Thank you so much.
Thank you, Mr. Schmeller. All parties are excused. Thank you. And I appreciate that. You were not misrepresenting. I understand what you're saying. All right. That's going to bring us to our last matter of the day.